Today, again, we'll be talking about navigating the pretrial system. And we have two great panelists today. But before we get to them, if anyone's on Zoom, you can see a little infograph on how to use Zoom if you're unfamiliar. So, always be mindful about your audio, muting when you're speaking, muting when you're not speaking and unmuting when you would like to participate in the conversation. You're welcome to show up on camera or off, however you want to show up. If you have questions you want to put in the chat, you're welcome to put those in writing, and I'll definitely make sure that you're heard. And then if you need to leave, there is the leave button. Something I also want to point out is that there's a live transcript that you can access to make sure that if it's helpful, you can have subtitles for what people are discussing in Lawyer Up. And so I'd like to move over to introducing our panelists. And I think we're starting with Eric Monroe. And so Eric, would you like to, just really briefly introduce yourself? Who's Eric and what brings you here tonight?
Yes, my name is Eric Monroe. I am a member of Alpha Justice. I'm here trying to navigate my way through a legal situation and also give my opinion on some of the legal issues that I might have had. Just trying to, come together, break through these issues that might come along our way. So for me, I'm here just to be a servant to my community, to the people who, share some of the same issues and trials that that they've been through in life, and educate myself so I can pass the information on to someone else that may have experienced some of the things or will experience some of the things that I'm going through or that I'm hearing. And as this point so far, that's what I'm here for.
Awesome.
If
Thank
I
you so
may,
much.
thank you so much, Eric. And I want to add a little bit more to Eric and his existence, because I think oftentimes when we're going through moments of navigating the criminal justice system, we're often identified just as that person going through the criminal justice system. Community will identify us that way because we're going through it. I've been through it. We identify ourselves that way. And I want to share that our existence is more than hit this transgression that we have to navigate, right? Eric is a father. Eric is a community member who shows up and supports his community. Eric has the program work. Dang, I forget the help me out, Eric. What's the program you just came from working with youth? You just did a lot of mentoring with youth this summer at Change for Real, right? I hope Uncle T will get me if I said that name wrong. Eric has navigated a lot of voting work here at Alfred Justice and was regarded as one of the best on the team. Challenge for change. Challenge for change. Did a lot of mentoring with young Black youth in East Baltimore over the summer with that program. Over the summer with Alfred Justice, help navigate and often lead our outside voting work and registering voters, and was often regarded by his team members as a leader, as someone who people trust, even when they could not get anything out of the community in terms of educating them about their voting rights. it has often been said that Eric has been the one able to garner community's trust. He is a man of faith, right? Uh, and he is a man who loves his family and engages heavily with his family. And so I just want to make sure that as formerly incarcerated people and as people navigating the legal system, because there are other folks on this call that navigate this system, like, let's give ourselves some grace. Let's acknowledge that we're greater than our mistakes, right? Or that this is just a part of the journey, and that we need to always tap into who we are at our essence. So I just wanted to acknowledge that before we go on to the next guest that Matt will introduce. Thank you.
Yeah, thank you, Nicole. And that's got some great perspective setting on how we always like to approach these issues as part of Lawyer Up and as part of our work. And so providing the other perspective and representing the Office of the Public Defender, we have Marianne Lima. And Marianne, would you briefly like to introduce yourself? What does pretrial mean to you as someone within OPD or the Office of the Public Defender?
Yes, hi everybody. My name is Marianne Lima. I'm the Pretrial Detention Initiative Attorney with the in Baltimore City, particularly, and I really appreciate being here because when you focus on the legal aspect and you're getting thrown case by case, it is so easy, like what Nicole said, to lose sight of the fact that you are representing a person. And my goal is to kind of get us back to that. My role at the office is to file a lot of the pretrial challenges. So after bail reviews, if there is someone that we need that, we feel should be out, has a particular set of circumstances, I do file habeases, bail modifications, things of that nature to continue challenging pretrial detention. My other ultimate goal, the formulation of this position, is to educate the judges on what the legislature is trying to do here and remind them that, everyone's presumed innocent, that not everyone before you should be in the position that they are, and kind of get that guidance from the upper courts. I also do train new incoming bail attorneys, so all the information I learn here will be really valuable to what I can then pass on to those coming after me, especially, if there are any ways we can improve as the legal office who's, representing the majority of the detained population pretrial, how we can better help you all, help the population either, holistically, even outside of the pretrial process. So, it's very important for me to connect with the community and know that what we're doing day in and day out, how that impacts the community. So I am really honored to be here and to learn more outside of the legal aspect of things.
Awesome. Thank you so much, Marianne and Eric, for sharing about yourselves. And so we'll be hearing more from both of you, but we thought it would be helpful to do some foundation setting. I think everyone knows something about the pretrial process. As far as what the process actually looks like, through and through, I think that is something people might have less familiarity with. And so, Marianne, I was wondering, could you tell the group, what actually is the pretrial process like? What steps are involved, for example, and then what are some of the basic issues that you see within that process?
Well, first, upon arrest, when you are taken to central booking, you are your first attempt at getting released is appearing in front of a commissioner. One of the issues I personally have with that is commissioners are not required to go to law school. So you are appearing in front of someone who is kind of just taking a fresh look at this, and whether they're experienced or not, they're making a determination on your liberty. And I find that a little problematic, but that's the way the system is set up in Maryland. You do have an opportunity to be represented at the initial commissioner hearing. They are a group of panel attorneys. It's not the public defender's office. I think that is a common misconception. We are not authorized to be part of the commissioner hearings. And what we found early on was that a lot of the clients were waiving their right to a panel attorney simply because you get to be in front of the commissioner quicker. And that was something that we wanted to try to dispel, is that, whether or not, however, I get the need to want to go see someone and try to get a bail as soon as possible, but it is a detriment to not have someone at least try to advocate for you. I think it's just, a lot of people were put at a disadvantage by just saying, I'm just going to get there quicker and try to get a bail. But after that commissioner hearing, if you are detained, whether they set a money bail or that you can afford, or if they hold you no bail, that's when our office steps in. So our office interviews you, and you then see one of the trial attorneys. We interview you by phone at this point because of COVID. We used to be in-person interviews, and now due to the mechanics of the jail, you get interviewed by an attorney over the phone. In Baltimore City, at least, it's a very abbreviated process, and it's one that we're still trying to work on, simply because the bail reviews in the city, at least for the males, occur at 11 o'clock. So from the attorney's perspective, you're handed a list of, anywhere on any given day from 5 to 12 people, and you're expected to do all those interviews, try to get as much information out of them as possible, so you can try to get them released within a matter of, at times 5-10 minutes a person. So the system is specifically not set up to be conducive to being able to convince a judge to let you go, even though you should be presumed innocent, and the presumption is that you should be released. And that's what the legislature says as well. The next stage, usually either the same day or the following day, you appear in front of the judge, and that's when your attorney will advocate for you to try to get released. And at that hearing, the judge has several options listed by statute. You either, at the very worst, hold without bail. After that, there's the most common thing occurring nowadays is release on home detention, which is typically a process, and I can get into that later, that is lengthier than people think. It used to be the case that the judges would authorize at the hearing, at the bail review hearing, and just sign a release. But now judges in the district court, at least in Baltimore City, are requiring that you file a motion and then a hearing be set so you appear at minimum, I think, the following week to advocate for your own release. So while it is a way to get released, it's still not a quick process by any means. After that, monetary bonds do still exist. The judge may say, post this much and you can be released. That's becoming less and less of an option for these judges because of case law that happened that says they need to do an in-depth inquiry as to whether you can afford that bail. And the sad truth is some of the judges just don't want to, go into all that. And it's a blessing and a curse that monetary bonds are now a thing of the past, generally speaking. We still see it every now and then, but it's very rare. Unsecured bond is another option. That generally means that, the judge sets an amount. You don't have to put anything up front, but if you fail to abide by their conditions that they set, they will issue a warrant for your arrest, and then you're liable for that amount of money. And then obviously release on pretrial supervision or less. So those are the options available to them, and that's generally the process. If you are detained past that point, we still have the options to file modifications and things on your behalf. But again, that is not a quick process by any means. So that's kind of in a nutshell. And a lot of the issues do center around timing, the fact that, there is not a lot of face-to-face interaction with anyone at this point with COVID. You appear in front of a video screen, so you're not even taken to court. You don't get to see your attorney, you're talking to them on the phone. So these are a lot of the problems that I see at pretrial right now, especially just for getting a final determination on your bond.
Thank you. Very informative. I think I want to elevate something that Nicole put in the chat. Nicole writes, money bond should be a thing of the past. And Marianne, you were just talking about money bond. So Nicole, what would you like to say about this?
it was a typo. I feel like since we have not dismantled bail like folks would think, it should not be a thing of the past. As many options as we have to get Black bodies free, we should use them. I feel like because of COVID, there became this heavy reliance on home monitoring, which is equally as harsh, if not more, considering that families do not have the option to get that money back, considering the restrictions it comes with. So I feel, especially as an advocate, and I know this could be very controversial in this moment, attorneys should be advocating for money bond, right? They should not have allowed this culture to shift all them from exploring all the ways to get their client free, right? So that's my perspective, especially considering there's a wave of financial support for our loved ones in terms of bail programs. There are active organizations who still have bond money available to get our people free. I think that the Office of Public Defender should not be, the culture should not have shifted in such a way that stops the defense attorney from pursuing money bond as an option or the other types of bonds as an option. I think we've allowed COVID and that climate to shift or a defense attorney, not even just the Office of Public Defender. I see it across the board with defense attorneys that they're not even asking, hey, Your Honor, could my client have an option for bail? They're just going straight to home detention. And if we're looking at weighing one's economic status like we do bonds and other things, then we should truly consider that because most of our loved ones cannot afford it. Yes, we've gotten laws that do allow for some programming to pay for home detention fees. But, my perspective is that we should be, defense attorneys should be exploring every option and trying every option. And they should not be just resorting to the most common thing in the now. That's just my perspective.
I could not agree more. I actually miss the monetary bond system at this point, given what's been going on with a lot of the majority of the people who would have gotten monetary bonds being held without bail at this point. The issue is that case that we were challenging money bonds on highlighted the fact that the statute says that the money bonds can only be imposed if you're a flight risk, that you can't impose a monetary bond to address dangerousness to the community. And the judges kind of took that and ran, right? So if there's no indication of any kind of flight risk, they think, well, now I can't set a money bond. And, I do still train the attorneys to ask, their employment status and how much they're making and request money bails. It's just another kind of backlash to the litigation that happened to try to get rid of money bonds was that it highlighted the fact that it shouldn't have been used for dangerousness in the first place. But I completely agree that we are now really quick to hop onto home detention. And I feel that the judges kind of have made it known that that's probably our quickest / only option for release in some of these cases. But I wholeheartedly agree that we should not stop advocating for that.
And lastly, we must not forget that the state, prior to COVID, operates its own home detention program, right? So I don't want to get into legislative jargon with you. I know we need to check in, but maybe defense attorneys could also request for their client to be a part of the state's home detention. I want all options, right? Like that's what I'm thinking, because prior to COVID, the Department of Corrections, at least for Baltimore, ran their own home detention. Yes, we needed to fix it and make it efficient, but it was a state operated situation, and I almost feel like we forgot that. I think we forgot that the state ran a home detention program. I often feel like defense attorneys, while pursuing home detention, they don't fight hard enough to remove restrictions, right? And so often our loved ones are forced to be at home, really can't fight their case freely because they have no opportunity for economic growth. They have no opportunity to engage with community. They have no opportunity to strategize about their legal defense too much because they're also stuck in a box. So those, when you think about pretrial, some of the things that we need from our defense attorneys is to think strategically at pursuing all available options for our loved ones, and in addition to that, thinking about the collateral consequences that being on home detention would does to us.
So something I want to uplift again from the chat before we move to hear more of Eric's perspective is that JViz says home detention becoming the default does not allow for work, school, and in some cases may cause safety concerns for certain populations. So that's definitely a perspective that a lot of people who are proponents of home detention maybe don't realize about, like, what are the collateral consequences of home detention, and the fact that it's not an alternative to incarceration, as was said, but it's just a form of it, right? And so I did want to move into the perspective of impacted people before we have a wider discussion. Thank you, Martha. Not to mention the cost and private profit, both very real financial economic struggles for people who are impacted. And before we turn to you, Eric, I know we also spoke to Philip about his experience. And so we just wanted to show a brief video about Philip sharing his experience. And Andy, would you mind sharing?
Yeah, let me just go to a quieter place to get the audio.
Just a quick plug for Balt's Instagram. Follow us at Balt Legal.
I was young, I didn't understand the system at all, but I realized that with the proper information going into my pretrial, I probably could have had my case resolved. But I was ignorant and nobody was there, so I was just going off the street stuff that I heard, misinformation. I would have liked to have somebody to intervene, to say, look, on your behalf, I want to be a stakeholder. I'm out here in the community. Let me go and have a meet with these people because ain't nobody dead in my case. I had attempted murder. I got 32 years in. And I'm saying, they didn't need to throw away no 19-year-old. And so I feel you 100% on that. And that's what I like to see, us to have a network of people on the ground that can meet with the prosecutors and say, look, he's from our community. We don't want to see him gone forever. You know what I mean? We already talked to the victims. In my situation.
Great, thank you. And so I think Philip touched on a few things that are actually common experiences for people going through the pretrial process, navigating it, maybe for the first time. And so Eric, thanks again for joining us. For you, how was your experience? And, did anything Philip say, resonate with you?
Yes, sure it did. I can relate to it a lot. I guess this why these situations is so important, because certain things you don't know or you're not aware of. These things we wasn't taught. We wasn't taught from my um, history and upbringing. We wasn't taught the law, and the importance of your rights and stuff like that. Like he said, it was the rights of the streets, your street rights, and things of that nature. So those are things that I was taught. So when it came to knowing the law that was created that you had to abide by outside of the streets that you was raised in, I knew nothing of. So it was already a trap set for me. And going through this trap, using the knowledge that I had, it wasn't good enough. It wasn't enough to fight the system that had rules and laws that was put in place. So sometimes when you don't know no better, you don't say nothing. And that can be one of the worst things you can do is say anything. Is just keep your mouth closed. So now in 2022, me being 41 and experiencing going back and forth to prison, experiencing being railroad, experiencing put my life in other people's hands, where such as public defenders, private attorneys, those people who supposed to represent me, I did experience not getting the best results because I still didn't know no better. I still look forward for others to know the law, know the things that was put in place for me. And now that I'm understanding that, you have to educate yourself. You have to, connect with people that's educating themselves, because you got to continue to educate the laws that's being made, because the laws is constantly, changing. The laws is constantly, evolving. So the law that was made last year or 4 years ago no longer exists. And so it's a consistent education that you have to take place and learn these things. So I guess, like I said, I can relate even to this day, where I'm still, battling with going back and forth to court. I am a living proof of being on a home monitor, home detention. And yes, all these barriers that's put in front of me, and I can only say that I believe that due to my faith, because I believe in God, something higher and powerful than myself, anything that exists on this earth, that because of my faith where it's at, then I'm able to continue to push forward, continue to see better days, continue to believe in myself, continue to believe in, God will connect me with people who have some of the answers that I don't have, that can give me some of the information that I need, that I can use to combat with the system or the laws that's put in place in front of me. So, that's just my theory. That's just my, my mindset, where I'm at now from what I've been through in life, dealing with this system.
Thank you, Eric, for sharing your experience. I think it's definitely some valuable perspective, firsthand. And I want to, again, uplift a message from Kenneth Baker, where you said, Kenneth, I somewhat agreed. And can you elaborate, if you don't mind, what did you somewhat agree with that Eric was saying?
I agree with the fact that, like, he's saying basically he need like some type of assistance to like he need assistance to like gain knowledge for certain legal troubles or just laws period. So that's all I was agreeing to. That some of us, like some people aren't
And if you cut out,
Yeah, I wasn't sure if that was me, but Kenneth, you did cut out. I'm not sure if you lost signal. Would you like to continue?
yeah, he probably lost signal.
Okay, well, we can always go back to you.
Yeah, we can hear you now, Kenneth.
I heard you for a
I
second, Kenneth.
want to remind people that the other part of the difficulties that attorneys must know is that we're in the era of the digital divide. You know, like not having access to the internet is real, right? And if you are forcing, or if it's a requirement that our loved ones have to engage with you by email or Zoom, and we're not able to do so in the way that you articulate it or the way you process it, it you could be your frustration or our loved one not having access to the internet, not articulating in the email what they want. It's also harmful to our loved ones. When I heard, it's kind of piggybacking off of what Eric said. I think defense attorneys, and I know that it's overwhelming. As an advocate that navigates the legal system a lot, I surely understand what it feels like to have a heavy caseload, but I also understand that I chose this position. You know, you chose to be a defense attorney. And so we make choices about our career path. And so when you have made a choice about your career path, the same way I've made a choice about mine, it's my obligation to give what I had available and consider other people's hardships in that. And one of those hardships is that you, as a defense attorney, practice the law. That's what you did for the years that you went to school. You learned to love researching the law, but that is not often many of our loved ones. You call them your clients. That's not their path, right? And so, or wasn't their path. And so consider that, consider that we may not know as much as you know, and we may not process information the same way, but it's your duty, it's your obligation to educate us and advocate, because attorneys are advocates too. Defense attorneys are also advocates. And so, I piggyback off of what Kenneth and Eric indicated about that knowledge, because the knowledge that we are gaining and learning every day about the legal system, like Eric said, it changes, it evolves. And so, for you, Ms. Lama, have a net, what is policy realm, and you also you're directly interacting with the caseloads as well, right? So you're able to see the policy now become implemented. And I think that many defense attorneys need to be updated on current policy, old policy, contradictory policy, so that they can better advocate for our loved ones. I wanted to pose a question if I could to Art. And I'm not specifically talking about one case over another, right? I'm asking if you could, if during the pretrial phase of whatever case you had, what was something that you would have liked your attorney to do or to say that could have triggered you to tell them more and push them more to advocate for you? I hope I asked it.
Yeah, you did. You did an excellent job asking the question. This will be like my first time actually doing a pre-trial in the streets, and any other time that I ever had to deal with some illegal issues, I had to deal with it in pre-trial, inside, behind the walls, whatever. So it's very, very difficult. And see, you don't have no legs when you're in there. You know what I mean? It's only, it's only but a short. You got like 5 steps, from your bunk to the phone. You know what I mean? And that's all you have. So, and that's limited because, when you want to get on that phone to talk to, your attorney about idea or something that you just read or something that you just came out with or whatever, that's dealing with your case, you know what I mean? You can't, you know what I mean? It's like, it's hard to connect the dots. And for an attorney that have other cases and you have lack of, resources to get to the attorney, it's awkward. And I think it's designed that way. You know what I mean? For you and your attorney not to have the best connection, when this one individual have several caseloads, and and it's very rare that you can actually get to your attorney, so I can't even really say which one. All of them, the ones that I ever had to deal with, that was behind the wall, you know what I'm saying? But it was more so just not having that communication that make you feel comfortable enough to feel like you so comfortable with communicating with your attorney that it's like impossible for you to feel uncomfortable. You know what I mean? It's a relationship, and that relationship cannot be built the way it's designed.
Yeah.
I go through it now, even being home. So just imagine if I was in pretrial in there, I would really, be stressed out.
Right. But let's
So
think
that's,
about it a little bit, Art. Let's think about it, right? Because
I
let's walk
think
this.
basically
Go ahead,
what
Kenneth.
he's
I think you fell through again, Kenneth. Are you on mute now?
And if you're in a bad area,
hello,
go ahead.
can you hear me?
Yeah.
Okay, I was saying I think he was pretty much like, I feel like a lot of us fail to
Kenneth, can you type it in the chat and because I think you're breaking up still. It might help
Okay.
us to understand what you're trying to convey. If
Yeah,
you can
type it in the chat and then we'll re-say it.
Yeah, we'll uplift it, Kenneth. Nicole, I
I'm
know
just
you were
trying to
speaking.
think though, man. Yeah, what I'm trying to pull out of Art and Kenneth is because we have an attorney on, right, who works in the office of public defender that can take back something to her team. And so we know that the system is flawed. I know it's hard to build a relationship behind those walls. But what I'm looking for is for us to give some solutions, right? We know the problems. We know them. We know the problem. But let's try to pull some solutions that she can take back. So I'm gonna try to pull out of you a little bit more, Eric, right? When we get locked up, and we've already went through that process of going through the commissioner. Now the law allows for that attorney to sit with us, that panel attorney to sit with us at the commissioner level. What information would you have wished that panel attorney had given to that commissioner to push for you, to tell your story, right? Because now you know that, like, it's the telling of the story, it's the personalizing you, it's the humanizing you that can get to that commissioner, because we know that commissioner is not coming from a real legal perspective at all. We're talking about an everyday citizen, like my mother or my aunt or your sister or your aunt or your niece, who, if they don't have a criminal record, can apply to be a commissioner and determine if you get out or not. Now, surely they have some guidelines that they go by, but we're talking about this human person. What could what could that panel attorney have said in that moment that could have better articulated why you should be free, or something about the case, or something that gave that commissioner some clarity? What could have been that thing?
Wow. I'm sitting here and I'm listening to you, and I'm just kind of like everywhere, because it
It's
took
okay.
me it took me different places. It took me a lot of places. You know what I mean? Because I'm playing back all the times that I ever was, going through that process, and the hurt, because I done got lawyers or panel attorneys or public defenders that showed me that they really didn't care. And I felt it before I even went into the courtroom. I felt it before my name was called. When you got 20, 30 people in a bullpen, and an attorney come and talk to you for 5 minutes, that's not enough.
Right.
For that person to know you or get to know you or speak on your behalf. So when you go into that room and there's no hope, because you already know that you're being represented by somebody that don't know you, somebody that haven't had a chance to get to know you, but they speaking on your behalf, right? So they might say the same thing that they say about the last 20 people that they didn't represent it. Oh, he's a dad. He's he's a citizen. He go to church, or he was in school. He has a job. Everybody got that. That's just the general, answer. But in detail, as an individual, I want to know about this person. Not I don't want to know about the people in society. I want to know about you. As an individual, you don't get that. You don't get the individual. You get what society is offering. You know what I mean? We got jobs out here, we got schools out here, we got colleges out here, we got programs out here, right? So we know that. But what about this individual? That it don't get that deep.
Yeah. I'm wondering, and tell me if you agree, Eric, right? And Kenneth, jump in when you did, or somebody tell me when Kenneth has typed in something. But I'm wondering if a solution, Lama, is because you hear Eric saying it's not enough time, right? One of the things I see in that small amount of time is the defense attorney not fighting back when the state brings up all these things, right? So the
See,
state will bring up things about the current case
right.
when we know that the defense attorney can object to that and say, Your Honor, that stuff is not proven. Like we know legally, and you correct me if I'm wrong, Ms. Lama, in a bail review hearing, you're supposed to own, in most jurisdictions practice this outside of Baltimore. You're supposed to, the state's attorney is only really supposed to bring up past stuff, right? They're not supposed to use the current situation as like factual, right? You know, this case was brutal, Your Honor. This case was, this person did this, like, because that case is not resolved yet, right? We're in the pre-trial phase. So what if a solution that we could offer is object more in the bail review? I tell attorneys, fight like you in trial when you in bail review, right? Fight for me like we in trial. You know, object to. Go ahead.
I was gonna say this, right? When you go into bail review and you got a attorney representing you, right? Within that 5 minutes window that they get to tell you what they're going to try to do, or we talk to your family, we made a phone call, 5 minutes, like I said, is not enough. So when they go in there and you got a state's attorney telling the judge, they reading your history. So they know more of your past than your attorney telling them of your present. They got 5 minutes of my present moment that I'm telling you about. But you done had all morning to go over my file, if not the night before, to go over my file from years ago. So when the state's attorney try to speak against me, then it's going to weigh more, because I have a attorney that's fighting for me, but that person only know of me for 5 minutes. And so, yeah, they won't really object because they really don't know who they're objecting for.
Mm.
You know what I'm saying? I'm going to speak up, but I'm not going to speak out.
Right.
Mm.
And I do want to just give a quick perspective on this whole discussion. And trust me, if in an ideal world, we would have much longer than 5 minutes. This is actually a very particular Baltimore City problem. A lot of other jurisdictions, like I said, have bail reviews in the afternoon. So you have all morning to, learn more and have time to interview. And it is a fight that we've been fighting. But unfortunately, the bench is just really resistant about moving the docket to the afternoon. That being said, it's no excuse, right? Whether you're a public defender or a private defense attorney, there's always going to be some bad apples in the bunch. And my job is to take what I'm learning here tonight and apply it to the future. And unfortunately, there are a lot of veterans set in their ways that will do this. Let's get this over with. Let's go. And quite frankly, I understand that a lot of the population feels that they're not actually being represented. What I'm trying to relate to the incoming class is that you do have to approach this from a humanized aspect, and that, that it's not just what's on the paper. There's actually one of the veteran attorneys who's one of the better ones actually does not even read the statement of charges before going into interview the client, because it shouldn't be that relevant, right? Because you're trying to get the background. And I do respect his approach on that. That being said, I feel like we're in between a rock and a hard place, right? Because we do, at least a lot of, the good attorneys do want to be able to convey that side of you. And that's what I try to tell the new attorneys I'm training. It's try to not focus what is being charged, focus the judge's attention on the fact that this is a person that exists outside of this piece of paper, right? But again, 5 to 10 minutes, you're right, Eric, there's not much, you can't possibly know everything about you. As far as the objecting and the state's attorneys, that's their routine, and it's really frustrating to us because you're basically just relaying the statement of charges, and that's not what's statutorily needed or, under case law required to hold someone without bail, right? Is that just because someone's charged with this offense doesn't mean that they're a future danger. You retain the presumption of innocence. And I have definitely pounded that into the new attorney's heads, and hope that that kind of resonates with the court. The state's attorneys, we are objecting to null process and stats and things that make the record look worse. But again, our office is also operating at a detriment where we don't get the records before we even walk into court. That is actually hopefully going to be remedied within the next 2 months. Pretrial has agreed to release the records to us, the whole background and their recommendation as well before we walk into court, because, we are reliant on the client to have personal knowledge of the extent of their record, and we're acting at a detriment there because in the state, state reads off what they know, and like Eric said, you're then focusing more on the past than the present. So I do appreciate all these comments, and I want to be able to take this feedback back to my office so we can, better represent our clients. It's a tricky situation, and I'm glad that I'm in the position that I'm in, because I want to be that stopgap between feeling like there's no more hope, right? So I thoroughly enjoy what I do, making sure that the people who are held without bond and don't feel like they were adequately represented do know that there is someone fighting for them to try to get out. The downside to that is that I am reliant on other attorneys telling me referrals. So telling me when there is someone who definitely should not have been held. There are a lot of situations, and probably, a good 60 to 80% of the cases that should be released, I don't even get to notice of because the attorneys just don't even feel the need to tell me that. But I think I love now that I'm getting more of is clients actually filing pro se habeas on their own behind the walls. And that also comes to me. So when someone files a pro se.
Thank you so much for saying that. Thank you so much. Thank you so much. Because thank you so much for saying that and acknowledging that people are able to file their own pro ses. They're able to file what we're calling a recall, right? Can you talk a little bit more about that? Because I know as a lawyer, you're trained to not advise clients to do that on their own. But like Eric said, our lives is on the line. And if we can't get in touch with our attorney, or we only got 5 minutes with our attorney, or we get a call from our loved one that they're still stuck in those prisons, community has to take action, right? And so can you educate us a little bit on how often one can get access to a pro se, how often one can file one, how often an attorney can file one, or how often a person can file one on their own, and a little bit of advice on what should go in that process.
Yeah, definitely. And so at least at central booking, I believe it's at every detention facility, they do distribute, if you ask for it, a pro se habeas form, and it's up to you to fill it out and just basically say what your bail is, and basically your reasoning for why you think that should be changed. And so what I see on those forms is, basically fill it with your background, and that's your opportunity to get it in front of a judge, what your attorney might have missed, right? Like aspects of your life that are being impacted by the fact that you are being held without bond. Additionally to that, any reasons why you don't, you're not a danger and you're not a flight risk, put that in there too. The other thing that I'm seeing is that if you don't file a fee waiver with that, it is getting denied. So definitely ask, I'm not sure if there's a regular form for that, but definitely ask for the pro se habeas form and the fee waiver. What happens after that is once it's received by the court, it is scheduled for a hearing, and that's usually where I come in. And that's actually where I get a lot of my successes, is that these are the people that slipped through the cracks and I wasn't able to file for them. So it's typically going to be me that then sets up an interview with you, goes over your whole background in the case, and what the best argument is going forward. And that's there's no restrictions on that conversation. There's no time limits. So I do feel like a lot of the pro se people who are advocating for their own on their own, unfortunately, just I want them to know that there is someone fighting. It's really awful that they had to get to the point where I'm going to do it myself. But I would like it to be widely known that you can. And there's no restrictions on how many times you file. I've seen people file like 2 or 3 times in the same detention period. What they don't know is what the outcome is, which is really unfortunate. So there, like, for example, there was a client who finally got a hearing. The last 2 petitions were denied because there wasn't a proper fee waiver filed. Why the court requires a fee waiver for someone who's incarcerated is beyond me, but it's just a formality that needs to be done. So if anyone's out there watching, definitely ask for a fee waiver as well. But you are entitled to a hearing once you file a habeas. And usually that's in the circuit court where the judges are more likely to release and unreasonable bail conditions. So it wouldn't return back to the district court.
Thank you so much. That's the type of education we need. So someone behind the walls should be, we talking Baltimore City, but other jurisdictions do offer more access to forms and documents. But just to repeat what you said, we're letting our loved ones know that if you are going to represent, file the habeas on your own behalf, what one generally needs to show that you're not a flight risk, you're not a public safety threat. A little bit more about who you are, what your responsibilities are in community, who your children are, a little bit more, and to make sure that you file or ask for a fee waiver with that. Is that the same process for folks who are free, who happen to get a warrant for their arrest? Because you have people free who are also pre-trial. They've been charged with something. Somehow they got a warrant. Is that the same process? Or can you share with us the process when someone who is actually free, technically, physically out in community, but still wanted, that want to file a pro se? What is that process?
Right. So if there's an active warrant for your arrest, what you'd want to do is either yourself or someone get a warrant recall motion at any of the district courts, and then fill out your reasoning as to why you don't feel that warrant is either valid or should be issued. And then you can either file it by yourself with the district court, and wait to see if there's a determination made on whether the warrant has recalled and a summons be issued. The other alternative is that you apply for our services and then we file that motion on your behalf.
Can I ask really quick? And I have JViz asking in the chat, how do you actually find a copy of this form? Like, where can people look?
Of the pro se habeas form?
Yes.
That's usually, unfortunately, what my clients say is that they just have to ask the COs for it. There's no, usually if you have a meeting with your case manager, that might be the best way to guarantee getting one. I've heard just asking the COs to get it. I also wanted to let people know that if they are represented by the public defender's office, you can also ask for an OPD attorney request form, meaning that you write down what you want your attorney to, contact you about if you haven't heard from them in a while, and that will get sent to our office. Unfortunately, we no longer have an office within central booking, but we do have someone who collects it and tries to distribute to their appropriate attorney or gets back to them some way or another.
Okay, so for the individuals who are not able to contact their attorney or are not hearing from their attorney, it could be a couple of reasons. Their attorney don't have updated information on you, or you need to remind them of your updated information. Can you please repeat what that form is called? A no PD form?
Yeah, it's an OPD attorney-client request form. So it doesn't. You don't need to know what attorney is assigned to you. It's a general I think actually the actual title on the form that we've used most recently is an OPD inmate request form. So we know that what facility you're coming from. It should be on the heading, and you can once again, I've seen people just requesting not knowing what their trial date is versus.
No, I'm talking about the free people. I'm talking.
Oh,
We
I'm
know
sorry.
what it
Oh.
is for the folks behind the walls,
Mhm.
but I see a lot of our loved ones not able to get in touch with their attorneys in general before a court case. Mhm.
Okay. So in that situation, I actually just urge you to call the office. I don't know what the success rate on that is. It varies by jurisdiction. If you're going to whether you're going to Hargrove, North Avenue, or Tapscott or Wabash, I would urge you to call that office and try to find out who your attorney is. Again, some are more responsive than others. I am going to leave my contact information here. I am always more than willing to help out. You know, I have access to the same assignments. Quite frankly, with the amount of shifting attorneys that there have been recently, there are times where we just don't know who's assigned the case, and that's a really unfortunate thing. But I can at the very least, have my contact information so you can contact me if there's any issues. But my first go-to would be the office of the courthouse that your case is coming into.
Well, what I know we have a time check and we're at that 1 minute, and I want you, Art, to have a 1 minute closing remark, and I want you to have a 1 minute closing remark. And I just want you to remind you that if somebody has an active open warrant, they are not going to the courthouse. They're not walking downstairs to the office of public defender. They're not doing that. Is there a for a contact, right? So say I got an open warrant, but I want to contact my attorney on another case that is not responsive. Are you saying the only way to do that, from based on what you know, is to call the different district offices to find out, to give a case number and to find out who that attorney is? What happens when that attorney does not respond? What's the next recommendation?
I see. The other option, I guess, would be to either send someone into the courthouse. You're looking for a warrant recall motion. There is a pro form, standard fill-in one for those as well, where you, excuse me, where you just fill in the case number. And again, the reason why you're requesting the warrant to be recalled, that can be filed by anyone, right? So even if the person who's requesting the recall isn't there in person, the person can sign off on the reasoning, and then someone else can file it with the court.
Yeah. Do you recommend if someone has an active case pre-trial and they cannot get in touch with their lawyer and they're getting close, 30 days out of their case, do you recommend people trying to contact a supervisor? What do you do in that case when you have not been able to reach your attorney for defense strategy or any of that?
Right. And I would contact the supervisor, because again, maybe it's a matter of the case not being assigned yet. The sad truth is, when I was in the throes of trial world, I would probably be operating 2 weeks out. So this is the harsh reality of the dockets, that I would be contacting my clients probably within 2 weeks of their trial date, not necessarily 30 days. And it's awful. But I usually try to do at least a check-in when I receive the file to see if there's any discovery that might be needed. But again, it's really a really bad situation time crunch wise. But if you haven't heard within the first 2 weeks, or if you're getting within 2 weeks of your court date, most attorneys try to operate within that time frame. Definitely try to contact the office.
Okay, thank you. And my closing question is, if you could have it your way, as an attorney engaging in pre-trial, what are some of the best practices, or what are some of the access, or what are some of the things you would want to see changed? And I know that's kind of pushing over to a legislative type of question, but if you had things your way, what would you like to see in your office?
As far as our office operations go, I would like to have more time with the clients. more opportunity for them to feel heard, because there are sometimes when you get on the phone and the client's like, oh, you're a PD, all right, well then here's this basics, I don't think I'm gonna get out. And I hate that feeling, right? That someone's already coming with a preconceived notion of myself. But it's understandable with the way the system's set up, right? In an ideal world, we'd have a lot more time with the clients. We'd have a bench more receptive to like legal arguments on these things. Not just ones that, fall into routine, see this kind of case and say, oh, this is what I'm going to do already without even hearing anything about it. We do see some members of the bench doing that. I would like to see it mirror more the federal level, where each bail review takes probably an hour or two to actually get into why someone's dangerous, and to be able to present evidence and to present testimony as to why this person is dangerous. We have so many instances where the complaining witness, alleged victim, comes into court and the judge still thinks they're too dangerous or would pose a danger to the person who's right there saying, he's not a threat to me. So I would love to have the evidentiary part of a bail review more, more meaty, so to speak, because I think it's becoming routine that you just hear from one side, you hear from the other side, and you already just check the box that you already know going into the courtroom as a judge you were going to do. So I would love to just see just like a very fundamental change in how we approach bail reviews to begin with, and to remind people that pretrial, you're not convicted of anything. There's nothing that you didn't, there's no proof that you did anything wrong. And I think that's lost on a lot of people as well, especially the state. And I got another ideal thing would be that all the parties involved in a bail review at least visit the jail once to see what you're trying to keep these people into. And I think that's the difference between a lot of the, the defense bar and the public defender's office and the other parties in a bail review, is that we know what happens when we fail. And it's something that it sticks a lot of us every day.
Thank you. And the same question goes to Eric. For Eric, I want you to because Attorney Lima, am I saying your name right? Lima?
It's Lima, but that's
Lima.
I get so many variations.
Lima. Attorney Lima, in an ideal world for her, he's thinking about kind of the bail review phase, right? Eric, I want you to think about after the bail review phase, because after the bail review phase, it's still pre-trial. Pre-trial means you are not at trial. The state and the defense is not prepared to bring all the evidence forth and have a trial. So I want you to think about the phases after, the engaging with the attorney, the talking about strategy, the evidentiary processes and that. I want you to get your headspace there and tell the listeners, what would you like to see? What are the best outcomes? What are the best ways that an attorney can engage you and educate you pre-trial? Also, or what are the behaviors?
I guess my answer would be, just being behind the wall for pretrial, having a better communication line. Like, I know it's hard sometimes to get through, but it makes the the defendant feel much better if the attorney sometimes reach out instead of us trying to reach them. So, like, even if you don't have too much, good to say, or new information, but just making a defendant feel like there is being thought of, and that you did take the initiative to reach out to the defendant, to show your support and know that they're not in this alone. You know what I mean? That's one of the main, biggest things. Like I said, sometimes a person gotta go a little bit above beyond their duty, their call of duty, especially dealing with people's lives and securities and feeling, comfortable, knowing that I'm representing somebody's life. She did mention, so she said something about this is pretrial. You haven't been found guilty yet. And be honestly with you that most people that fighting the case already feel guilty, even if they did it or not, right? They say they did do it, but they wasn't found guilty. See, how I was raised, with the knowledge that I had, that you can't win. So even when it's a possibility that you can beat the case, but because you pretty much know you did it, you give up. We already give up, so we don't try to fight it. And most of my cases, I pleaded out. I copped out because I already in my mind programmed myself to feel like I got caught.
To feel defeated.
Right,
Yeah.
right. So
Yeah.
so even though they caught me wrong because they violated a lot of things to catch me, I didn't know that.
Well,
I'm not
I
thinking of
don't
it that
want you
way.
to get too deep. I don't want you to get too deep in discussing any concerned facts or what you think
No,
they had or what you
no,
think
but
they
this
didn't have.
no this just in general, like this prior to and
Okay.
I'm just, like I say, speaking of other people who going through the same thing that
Yeah.
don't know. Like we already convict ourselves before we've been convicted. And that's just somebody saying that you count yourself out on your own, like you killing yourself, you destroying yourself. That always, you gotta always fight, because
Right.
that's how you win. Because you thinking the person is stronger than you, you doubting your own strength. So these things like this help me grow. My experience helped me, make better decisions, learn more. When I'm, be able to defend myself better throughout life. So, I guess if I didn't answer your question, like I
No,
say,
you did.
in pre-trial, for the most part, what would make me feel more comfortable and safe is that I could somewhat reach my attorney, because that
Okay.
becomes my best friend. You know what I'm saying? That
Yeah.
becomes my everything, because I'm looking to connect with this person so bad in a way. I'm just looking for the connection. You know what I mean? That
Yeah.
makes me feel like I can just relax and not really, let my attorney do everything, but I can feel at ease and we can do this thing together.
Right.
You know what I'm saying?
Right.
A lot of times we don't feel like we on the same page. Feel like, I got somebody fighting with me or fighting for me, but we're not fighting together. You know what I'm saying?
Right.
A lot of attorneys and the defendants don't really be on the same page a lot. And I don't know if that's because the lack of communication, and we always say communication is the key to everything, to any relationship, to anything, what I mean, that we try and build and be successful in. We got to communicate it. So the less communication, the week of, the process
Yeah.
of what we're trying to do. So yeah, that's all.
Yeah,
No,
thank you, Eric.
that's facts, because when you don't communicate, it leaves room available to wonder, right?
Right.
Yeah. Um, it's Kenneth in the good area, and I know we going over, but we did start a little.
Yeah, so Kenneth is no longer in the room, but JBiz does seem to echo what's being said. That's why both advocates and attorneys are important. But
Yeah.
what you really want is your attorney is a zealous legal advocate. And so I think we're seeing on both sides yeah, you really want if your attorney is a zealous legal advocate. And so we can see on both sides, what are the perspectives on the pretrial system, and how can, we bring these visions closer together to
Yeah,
move
and
towards a
I'll
system that
close
is
on this
less
one.
harmful.
I promise. I'll close with this. One of the things I want to see attorneys do more pretrial is fight for the lesser charge. Don't allow, don't settle for the charge that was given to your client. Fight to get the charge reduced, right? Don't just settle for what the police decided or what the state's attorney at central booking decided. That during pre-trial, you try to fight to get those charges removed. You try to fight to get the state to, even if it's inconvenient, to recharge and charge with the lesser charge. Drop the more harsher charges and try to convince them to recharge under the lesser charge. Those are the things that I want to see more in my defense. You know, community. I want to see them not, I want to see what Irk said, but I also want to see that when we are in pre-trial, that the goal is always to think about the collateral consequences that our loved ones will face if they go to trial or if they plead before trial. And so, we understand that sometimes pleas are what makes sense in different situations, right? But in every situation, what I would like to see in a defense attorney is always pushing to get the charge reduced down to the more to the offense that's eligible for expungement. Because I hate seeing my loved ones come in my office after having an offense for the last 5 years and 10 years, and we have to tell them that they gotta wait 15 more years. And just maybe if at pre-trial that defense attorney could have fought harder to get the charge reduced, or if I'm talking about now trial and pleading, but yeah, reduction of charges, fighting for a reduction of charge, fighting for before trial that attorneys try to convince the state to recharge with the lesser charge or amend the charge to the lesser charge. That's what I'll close with.
All right. Thank you, Nicole. Thanks everyone who joined us to speak today or just to listen and learn. Big shout out to Eric, Kenneth, Philip, Marianne. Thank you so much for sharing your different experiences. And Marianne, you said you wanted to share your contact information before we dropped off. So could you put that in the chat?
Mm-hmm. Yep.
Yeah, and again, thank you for generously, offering yourself as a service or resource to the community. I think clearly from tonight's conversation, that's much needed. And more access to attorneys is something at a basic level that can help address some of these issues. And so that's Marianne.Lima, MARIANNE.LIMA at maryland.gov. Or at 443-300-7434. And yeah, just again, I know we're over time, so thanks for joining us. And I hope everyone has a great evening. Thank you.
Thank you. Thank you.